Hi, my name is Emily Kile, and today we are going to talk about the supported decision making, which is legislation that just passed in the state of Arizona and won't go into effect until sometime in September. But I wanted you to be aware of it. And of course, it might change over time, so you'll have to check back because it is brand new and we've never had it before. So we're just kind of walk through what the statute says. We also do have a draft sort supported decision making agreement, which you can find on our website as well. So we hope that you'll have the opportunity to use that. Understand with the agreement, you can have more than one decision maker. So you may or supporter, I should say. So you might end up with a bunch of agreements if somebody wants to have different supporters for different decisions. So let's go ahead and get started. So what is supported decision making? I can't even say it yet. It's so new. So this is how our statute defines it, and different states who have adopted this SDM process have different decisions. But basically, it's a means of and a process of supporting and accommodating an adult to enable the adult to make life decisions. So the goal is to not impede the adult's self-determination so they can continue to be 100% their own self-advocate. And honestly, we all use supporters, right? We go to family and friends, we talk to counselors, we go to professionals, and we gather all the information that we can gather, and then we make a decision. It's just not as formalized of a process as this supported decision making in our legislation now would be. However, we have to make sure that the person who wants to enter into such an agreement is competent to make their own decisions. So from our statute, an adult means an individual with a disability who's at least 18, because in Arizona, the age of majority is the age of 18 years old. They have some kind of a disability, whether it's a physical or a mental or other impairment that is limiting some of their life activities. And the supporter is also a person who's an adult, so somebody who's over the age of 18 years old and who enters into that supported decision-making agreement with the adult. I've also given you the definition of an incapacitated person because an incapacitated person cannot enter into a supported decision-making agreement. If your loved one is able to sign a power of attorney, then an SDM agreement is not appropriate. They should be signing a power of attorney. So just like I have a power of attorney, you should have your estate planning done. And that says, if I become incapacitated and become an incapacitated person, then somebody can make my decisions for me. Or for financial power of attorney, you could have that be effective immediately and say, it's okay now for my agent to access my bank accounts. If your loved one cannot be their own self-advocate and they are an incapacitated person and they can't communicate responsible decisions to somebody else, then an SDM agreement is not appropriate for them because, again, they have to be able to understand and they have to bring the information forward and make their own decisions as their own self-advocate. They're only coming to you under the agreement or whoever their supporters are to gather information as to who is going to be their go-to people or their committee of people to make those decisions. So the scope of the agreement can be pretty wide-ranging. It's just to help the person make all kinds of decisions, whether those are medical, financial, education, whether it's to gather the information, assist in communicating that adult's decision to the appropriate people who need to know it. But most importantly, a supporter is not a surrogate decision maker for the adult, and they do not have the authority to sign legal documents on behalf of the adult or bind the adult to a legal agreement. So if I am the agent for an incapacitated person I can sign, when they go to the hospital, I can sign the agreement to have them admitted as agent for the person. And I am not binding myself, I am binding that person to those treatment decisions. If I'm an agent for somebody financially, I can pay their bills. I can direct payments to whoever it is that needs to be paid. If I am a supporter, I am just a supporter. I do not have the authority to sign their legal documents. Again, because it's so new, we don't know for sure how it will work, but probably you're not going to be able to call customer service and say, I'm a supporter for my child and I need to get this information, or I want to dispute a charge on their credit card, or any of those things, because that person at the other end of the phone doesn't have that supported decision making agreement. Or even if they do, our statute says you can't bind them to some other kind of a decision that they're making. If you're a guardian or a conservator, you have a court order that you can provide to that third party. If you're an agent under a power of attorney, you can provide a copy of that power of attorney document. But remember, you can't bind them or sign on their behalf. You can only support what it is that they're asking for. Obviously, you can't intimidate or deceive them, and a supporter is not entitled to compensation as a result of their duties under the agreement. As always, we want to avoid conflicts of interest and self-interest in making decisions. So we hope that your loved one is not going to choose people who are going to take advantage of what might be some vulnerabilities for your person, but that they've chosen people who are going to be supportive and help them, and sometimes challenge their decisions as to what they may want to do or what they think is right. But remember, the adult who signs the agreement does not have to listen to what the supporter suggests or rely on the information provided by that supporter. So the agreement has to be signed by the adult, or if they're physically unable, then to direct somebody else to sign them. And either you need two witnesses or a notary in order to make the document valid. And I would note that none of the supporters should be the witness or the notary on that agreement. So it can be terminated in writing by the adult person or by the supporter. If a guardianship is instituted and a guardian is appointed, then that appointment of a guardian automatically terminates the supported decision-making agreement. And of course, anytime the adult becomes incapacitated, that would terminate the agreement, because then they would not be able to advocate for themselves any longer. So for example, if you have a person who has a developmental disability and they sign a supported decision-making agreement, and then later they get in a car accident and have a traumatic brain injury and are now an incapacitated person under our statute, you probably will petition the court to become guardian and or conservator if there are financial issues, but that supported making decision agreement will have terminated. So that's kind of look at what supported decision making is and what it's not. So it's a practice to help support people with a disability, but who are competent. You have to have a written agreement, and then the supporter can provide input on decisions. Again, the adult who you're the supporter for does not need to follow whatever decisions you think are best for them. The adult makes all of their decisions voluntarily, but it is a way to help the person come to their own decision so that they have input from other people about some decisions that they're making. So it allows that person to take risks, make mistakes, hopefully learn from those mistakes. But supported decision making is not a way to make decisions for a person who is not competent, and it's not a way to make decisions for a person who is competent. It's only to provide information. It's not a power of attorney, and it's not ordered by a court. It is absolutely not a way to coerce a person with a disability into making a decision that the adult thinks is best for that person or best for the supporter. And it is not an opportunity to protect, I put that in quotes, a person with disabilities from making a bad decision. If you are a competent adult, we all make bad decisions and look back and think, oh, I should have done something differently. And that is the same even under a supported decision-making agreement. The agreement does not allow the supporter to bind the adult to a legal document, as I said previously. So I have autonomy and then supported decision-making and then guardianship. But honestly, for most of us, we are, if a person is competent, I guess I would say, they have the autonomy to make whatever decisions they want to make. We all go and seek support from people we trust, and that's what supported decision-making is about. And then, of course, we have guardianship at the other end, which says that the adult is now an incapacitated person and cannot make those decisions on their own. And therefore, somebody else has full autonomy to make decisions, even if the person under guardianship disagrees with those decisions. So who can be a supporter? Pretty much anybody. A caregiver can be a supporter, a parent, a friend, a religious advisor, a sibling, pretty much anybody that that adult trusts to help them make decisions. And as I said, a supported decision-making agreement could be for medical decisions with one person or two people or a committee of people, and making housing decisions might be completely different people. So the person can have more than one supporter and more than one supported decision-making agreement. So supporters are there to help the adult make their own decisions about what it is they want. Supporters can attend meetings, they can attend appointments so that they can hear the information directly from that provider. The adult can also say, I don't want you in this particular meeting, or I don't want your input on this decision. This is the decision that I'm going to make. So it is all still at the discretion of the adult, not the discretion of the supporter. Always, always, always the adult makes their own decision, not the supporter. The supporter just provides input into the decision if it's requested by that competent adult. As I said, the agreement can be about all kinds of major decisions. Housing, healthcare, all kinds of things, finding a job, all of those things. So here are some examples: finding a place to live. So maybe the adult needs some help figuring out, how do I look for an apartment? Reviewing documents. What is the lease agreement? What are my obligations? What are my monthly expenses? Are utilities included? Do I have to separately sign up with an internet provider? It could be helping them to make medical decisions and attending medical appointments. If the adult signs a release for medical information, then the supporter can get access to the medical records and then can review them with the adult to make sure that appropriate decisions are being made. Maybe it's about talking to Access or DDD or the Social Security Administration with the adult, or being on the phone during the appointment for the interview, or helping them to understand what's being requested of them at the time of a renewal and what information should be disclosed. It could be about education decisions. And again, if they sign a separate release, then the supporter can get access to those education records. Could be to find a job. Where do I look for a job? How do I write a resume? How do I set up a time to meet with the HR department? Whatever those decisions might be. This is obviously very different from a guardianship, because a guardianship is a court action that's to protect the incapacitated person, and the guardian gets to make all the decisions, and the protected person's rights and choices are taken away. Although also in a guardianship, the statute is very clear that the purpose is for the guardian to always take into account what that incapacitated person would want and make decisions that are in their best interest. But the guardian is making decisions just like a parent does for a minor child. So very different from what happens in a supported decision-making situation. And because our statute is so new, it's going to take some time to see how well it works, any changes that might need to be made to the legislation, what can be done in order to make it better, both for the adult and for the supporter to be helpful. So I hope this was useful to you. Again, you can go on our website and you'll be able to see a sample of a supported decision-making agreement. I wish you the best. And if you have any questions or need to schedule a consultation, our contact information is below. Thank you so much. Again, I'm Emily Kile.